Hello, everyone. I am Hayden Warren. I'm a resident of Northwest Ohio, and I'm here to present a logical argument based on Ohio law and human biology about why non lethal civilian resistance to unjustified police force should be legal. When the human brain perceives physical threat, it triggers involuntary defensive reactions. Current Ohio law criminalizes these reactions against police officers, even if the force is unjustified. I wrote a whole detailed paper on how this conflicts with biology and law. I want to acknowledge up front that, like anyone, I come to this with my own perspective, but this argument is grounded in biology, legal texts, and principles of human dignity, not personal grievance or emotion. If you don't want to hear any of this, then please kindly leave. None of this is meant to attack anyone. I am not personally insulting any officer for how they've been trained. I just want to share my view. Okay. Bodily autonomy and the legal limits of authority in Ohio. A case for proportional non-lethal resistance. This paper proposes a legal reform to Ohio's current approach to non-lethal resistance against law enforcement officers. It does not advocate violence nor oppose legitimate policing. It instead addresses the legal asymmetry that prohibits civilians from responding physically to unjustified physical force by officers, even when such contact is aggressive or provocative. This argument is rooted not in emotional appeal, but in observable biological response, legal logic, and the need for a rights-based equilibrium. Biological and cognitive response to physical aggression. When the human body receives a physical threat, the hypothalamus activates the sympathetic nervous system, initiating a physiological chain reaction. Cortisol and adrenaline are released, increasing the heart rate, muscle tension, and preparing the body to resist. Another part of the brain assesses the threat level, often bypassing slower cortical reasoning. This results in a preconscious defensive reaction, such as pulling away, blocking, or pushing, before deliberate rational analysis occurs. These responses are involuntary. They are not acts of willful defiance, but are neurobiological imperatives. The legal system currently criminalizes such autonomic actions as resisting arrest or assault, even in instances where no arrest has been declared, no weapon is present, and the civilian has not posed a violent threat. Current Ohio statutory framework. Ohio Revised Code 2921.33 defines resisting arrest as using force against a law enforcement officer to prevent or hinder arrest. Revised Code 2903.13 elevates assault to a felony when committed against a peace officer. These laws make no distinction between lethal and non-lethal force, nor do they consider whether the officer's initiation of force was proportionate or necessary. Ohio Self-Defense Law, Revised Code 2901.05, permits defensive force when an individual is not at fault in creating the situation. However, in practice, courts do not permit this defense against officers acting within the scope of duty, quote-unquote, even in cases of questionable necessity or provocation. This results in legal protection for the state's actors' use of force, but no legal shield for the civilian's proportional response. Proposed legal reform. A civilian should not be subject to criminal liability for non-lethal, non-escalatory physical resistance to unjustified or unnecessary force by a peace officer under the following constraints. 1. The civilian uses no weapons or instruments. This includes knives, guns, anything to increase hit power, or things they find around like rocks, dirt, gravel, etc. 2. The civilian causes no serious physical harm as defined in 290101. The civilian ceases resistance upon disengagement or de-escalation. The incident arises from a non-violent offense or investigatory contact. This reform would create a narrow affirmative defense or statutory exception permitting proportional physical self-preservation in situations where the law currently demands total submission regardless of context. Practical legal justification. Legal systems distinguish between proportional and excessive force in nearly all contexts, except this one. For example, mutual combat, domestic self-defense, and even property defense are all governed by proportionality. It is legally inconsistent to deny that same you understand, to civilians facing unprovoked physical force from state actors. Furthermore, bodily autonomy is a foundational constitutional principle. The government may not compel medical procedures nor detain without due process. Yet, physical grabbing, pushing, or shoving by officers without formal arrest, probable cause, or violent exigency is permitted, and resisting such contact criminalized. This contradicts the physical principle of bodily sovereignty. Okay, I messed that word up. Apologies. Officer safety and policy considerations. This proposal does not hinder officer safety. It excludes violent crimes and weapons. It does not legalize striking officers with intent nor injuring them. It limits its application strictly to unarmed civilians responding to non-lethal, unjustified physical contact. Officers operating within proper use of force guidelines, particularly those trained in de-escalation, would not be affected. Rather than endangering police, this standard would incentivize procedural clarity, reduce unnecessary escalations, and reaffirm that enforcement power does not override individual rights absent legal cause. Conclusion. Non-lethal resistance should not be criminalized in all circumstances, particularly when it is a natural defensive reaction to unjustified physical contact. Ohio law should reflect a balanced standard, one that acknowledges the biological reality of self-protection, the legal principle of proportionality, and the constitutional rights of bodily integrity. Legal authority must remain subject to reason, restraint, and doing it back to them. If anyone would like to argue this or talk about this with me in any way at all, my email is stratuswarren@gmail.com. STRT